So our next speaker is Tina Minkowitz. She is an international human rights lawyer, lesbian feminist, and a survivor of psychiatric institutionalization. She is the president of the Center of the Human Rights of Users and Survivors of Psychiatry. Tina represented the World Network of Users and Survivors of Psychiatry in drafting and negotiations of the Convention of the Rights of Persons with Disabilities. She has continued since the Convention's adoption to shape the interpretation of the Convention in this regard, through contributing to expert meetings and UN consultations. On a personal note, I think Tina's influence in this area is almost, for us as survivors of psychiatry, it's so huge. And for VSO, We Shall Overcome, we first invited Tina to Norway in 2008 at the 40th year jubileum of our organization to present for us about CRPD. And this has shaped our work a lot later than that. Tina.
Thank you. So, it's a real pleasure to be here with all of you here and everyone online. I have the amazing task of talking about CRPD-based standards for ending psychiatric coercion. I'm going to actually assume a little bit of familiarity with some of the basics, like the fact that Article 12 of the Convention requires states parties to recognize the legal capacity of persons with disabilities on an equal basis with others, to provide access to support people may need in exercising that capacity, and that all measures relating to the exercise of legal capacity are to be based on the rights, will, and preferences of the person. And on Article 14, that Article 14 of the Convention guarantees to persons with disabilities liberty and security of the person on an equal basis as others, to not be detained arbitrarily or unlawfully, and that no deprivation of liberty shall be based on the existence of a disability. And that if people with disabilities are detained through any process, they have equal guarantees as others in that situation, and also the guarantee to be treated in accordance with the objectives and principles of the CRPD. So I kind of want to get that out of the way because I'm going to get into the detail about the standards. I also want to just start out by saying we're talking about reparations here. All of the work that we're doing in creating the CRPD, in developing the standards and implementing them and fighting for our human rights in this way, all of this work is a reparative enterprise seeking redress for violations that were not recognized as such by the world community until the CRPD came into being, despite survivors' advocacy. I know We Shall Overcome started in 1968, the longest-running organization of users and survivors of psychiatry in the world that I know of. And, you know, despite our advocacy, there were others that started around the same time, and the movement was starting around that time, the modern movement. So despite our advocacy, we had not succeeded until we brought our issues under the framework of disability non-discrimination and participated in the process of CRP drafting and negotiation and contributing to the interpretation of that convention by the CRPD committee and other UN experts. I also want to say some other sort of core assumptions that I'm making here that are relevant to everything I'm going to address. Law reform is a core requirement under Article 4 of the CRPD, and that is one of the things that's essential to ending psychiatric coercion. It's addressed under all the topics below. Another obligation under Article 4 of the Convention is the active involvement and close consultation of people with disabilities through their representative organizations in all processes relating to their concerns or their rights, especially the implementation of the Convention. For me, a third important thing is an understanding of psychosocial disability as diversity, requiring demedicalization and social acceptance, which is needed to root out the intolerance that leads to institutionalization and forced interventions. That's a theme that comes up in some of the materials I'll be addressing. And I want to, the first thing I actually have up as a reference is something most of us don't think about too often. It's a little reference in the guidelines on Article 14 of the CRPD committee, where they took somewhat of a diversity-based approach to disability, saying impairment in the present guidelines is understood as a physical, psychosocial, intellectual, or sensory personal condition that may or may not come with functional limitations of the body, mind, or senses. Impairment differs from what is usually considered the norm. And, you know, the committee, I mean, this is one little statement that they included in the guidelines on Article 14 because they were using the term impairment and did not want to use it in a way that would appear to be medicalizing psychosocial disability. The next thing I actually want to go to is general comment number 1, because we're going to start with legal capacity. And I'm starting with general comment number 1, paragraph 42, which really summarizes pretty much the implications of the general comment for the ending of psychiatric coercion. And that's framed as being the linkage of Article 12 with the articles relating to the right to personal integrity. As has been stated by the committee in several concluding observations, forced treatment by psychiatric and other health and medical professionals is a violation of the right to equal recognition before the law and an infringement of the rights to personal integrity, freedom from torture, and freedom from violence, exploitation, and abuse, which are Articles 17, 15, and 16, respectively. This practice denies the legal capacity of a person to choose medical treatment and is therefore a violation of Article 12 of the Convention. States parties must instead respect the legal capacity of persons with disabilities to make decisions at all times, including in crisis situations, must ensure that accurate and accessible information is provided about service options and that non-medical approaches are made available, and must provide access to independent support. And I leave out a little bit, and it goes on, states parties must abolish policies and legislative provisions that allow or perpetrate forced treatment, as it is an ongoing violation found in mental health laws across the globe, despite empirical evidence indicating its lack of effectiveness and the views of people using mental health systems who have experienced deep pain and trauma as a result of forced treatment. And they recommend that states parties ensure decisions relating to a person's physical or mental integrity can only be taken with the free and informed consent of the person concerned. So they have everything there. They have a move towards demedicalization, ensuring non-medical approaches are available. They have recognition of the harm. They have the acknowledgement here that it infringes the right to freedom from torture. In the guidelines on Article 14, they go on to characterize it as a violation of Article 15, the freedom from torture and other ill treatment, the obligation to abolish the laws and practices, and that there's somewhat of a heightened concern on free and informed consent. Legal capacity is foundational to all rights, It's implicitly or explicitly removed in the forced psychiatry system. Either there's a standard of incapacity to make a treatment decision, or there's simply the assumption that mental illness or unsoundness of mind warrants segregation control, compulsory treatment. Incapacity and danger to oneself or others are twin stereotypes that really underpin the system of forced psychiatry. So incapacity is always there, whether or not it's made explicit. And the committee does say in general comment number 1 that forced treatment regimes are equally with guardianship regimes a kind of substitute decision-making, and all substitute decision-making has to be abolished under the convention. Legal standing and legal agency are both aspects of legal capacity. Both have to be guaranteed equally to people with disabilities. There can be no functional capacity or mental capacity argument to remove a person's legal capacity. Here again, I'm going to quote from the general comment. In most of the state party reports that the committee has examined so far, the concepts of mental and legal capacity have been conflated so that where a person is considered to have impaired decision-making skills, often because of a cognitive or psychosocial disability, his or her legal capacity to make a particular decision is consequently removed. This is decided simply on the basis of the diagnosis of an impairment, which is the status approach, or where a person makes a decision that is considered to have negative consequences, the outcome approach, or where a person's decision-making skills are considered to be deficient, the functional approach. The functional approach attempts to assess mental capacity and deny legal capacity accordingly. It is often based on whether a person can understand the nature and consequences of a decision, and or whether he or she can use or weigh the relevant information. And I think the next sentence is key. This approach is flawed for 2 reasons. A, it is discriminatorily applied to people with disabilities, and B, it presumes to be able to accurately assess the inner workings of the human mind, and when the person does not pass the assessment, it then denies him or her a core human right, the right to equal recognition before the law. And I think that's key because one of the main ways that our rights are violated by the system of forced psychiatry is in not recognizing that we actually have an inner world that merits respect on an equal basis as other persons once psychiatrists have decided to stick a label on the person. And people do experience themselves as active. The mind does not shut down. The soul, the spirit, the emotions do not shut down. The will does not shut down. So, all of those approaches are illegitimate under Article 12, and support must be provided instead. And also, there's simply an obligation to respect the person's decisions. Support must respect the person's will and preferences, and there also must be accommodation for different ways of communicating and decision-making. Support can be any kind of personalized arrangement to assist in understanding information, communicating, or making a decision. There is a right to accept or refuse any support. You cannot condition the recognition of legal capacity on a person's acceptance of support. There's a right to simply make one's own decisions and decline any offer of support. And there's a right to change or modify a support arrangement at any time. Advance directives, which some people value a great deal, advance directives can be an aid to knowing a person's will when communication and decision-making are difficult, but should be subject to the person's contrary decision at any time, since they retain legal capacity in crisis situations. And I know there's some debate on that question, whether or not so-called Ulysses Clause advance directives are legitimate under the convention, whether they're desirable. In my view, if people retain legal capacity at all times, including in crisis situations. We have to simply respect that, even if the person wrote something saying something else at an earlier time. There is a provision for a best interpretation of will and preferences instead of the old best interest standard as a stopgap measure when it's impossible to discern the person's will, which the paradigmatic case of that is if a person's in a coma. And if anybody's trying to use best interpretation and the person's not in a coma, you really have to think, is this comparable to a coma? And I would argue psychosocial disability is never or almost never equatable. I don't think it's equatable ever really to a coma. So you have to be very careful with people offering a best interpretation approach to ending psychiatric coercion. Interpretation here is the key word. It's a good faith attempt to approximate what the person themselves would do if they were in a position to communicate their will, because it's interpretation. It's only applicable when it's not possible to know. So if the person actually indicates their disagreement in any way, the assumption was not correct that it's not possible to know their will, and they're expressing their will directly. So whatever, you have to stop doing this best interpretation. It's a term of art here, because we know that we're always interpreting one another's communication. And there has to be an approach to accessibility in communication when dealing with any kind of disability related to communication. But the term best interpretation in the general comment is really a term of art for making this process of trying to understand what the person's will might have been if they were in a position to communicate. In the context of psychiatry, affirmative expression of free and informed consent by the person concerned is always required because of the controversial and intrusive nature of the interventions. So the best interpretation cannot be available in any case because it's just too dangerous a situation in order to prevent the recurrence of forced treatment. That's what, that standard has been articulated in the guidelines on deinstitutionalization now. So if it's not possible to discern the person's will, either directly or through an advance directive that the person has not disavowed, don't use psychiatric drugs. In other words, caution, err on the side of caution in that case. Let's go to liberty. And the primary reference document on interpretation is the guidelines on Article 14. Disability-based detention is discriminatory and therefore arbitrary under pretty uncontroversial international law, that discriminatory detention is a form of arbitrary detention. There's an absolute prohibition against disability-based detention, which the committee wrote in the guidelines on Article 14, with no exceptions, whether the detention is based on disability alone, in this case based on just the fact that a psychiatrist has diagnosed the person, or in combination with factors such as danger to oneself or others or need for care and treatment. The committee repeated that, I think, several times in the guidelines on Article 14. It's a very important premise, and it's in part based on the negotiating history of that provision. Okay, here again I'm going to quote. The committee has repeatedly stated that states parties should repeal provisions that allow for the involuntary commitment of persons with disabilities in mental health institutions based on actual or perceived impairment. Involuntary commitment in mental health facilities carries with it denial of the person's legal capacity to decide about care, treatment, and admission to a hospital or institution, and therefore violates Article 12 in conjunction with Article 14. There's an obligation to release those detained, which was first stated in general comment number 5, and I'm going to start moving a little more quickly because I'm concerned on time, so I'm not going to read that one, but it will be available in materials after the conference. The committee also addressed the criminal justice system, because that's important both as a site of disability-based deprivation and as part of an important framework of how any kind of psychiatric commitment is understood, whether in a criminal process or in a civil process. There's the view of incapacity and dangerousness is linked to mechanisms like the insanity defense that find people incapable of being held criminally responsible or being punished. But then there are these other systems that put the person under a medicalized control that's often more draconian. So the committee has established that declarations of unfitness to stand trial or incapacity to be found criminally responsible in criminal justice systems and the detention of persons based on those declarations are contrary to Article 14 of the Convention. And I am going to skip some things. The committee has called for states parties to remove those declarations and has recommended that all people with disabilities simply be allowed to defend themselves and be given support and accommodation to facilitate their effective participation, as well as procedural accommodations to ensure fair trial and due process. The guidelines on Article 14 also encourage restorative justice and other alternatives to incarceration, but these cannot involve transfer to mental health commitment or require participation in mental health services. I'm going to move on to torture. So this is one of the things that is important to me. I'm not sure how well known it is because it's prior to the CRPD. In 1986, the first UN Special Rapporteur on Torture, whose name was P. Koymans, found that neuroleptics, I'm going to read this, he wrote the following list, which is not exhaustive, refers to some methods of physical torture. And he included there the administration of drugs in detention or psychiatric institutions, among which he has neuroleptics that cause trembling, shivering, and contractions, but mainly make the subject apathetic and dull the person's intelligence. Recall, he wrote that in 1986. In 1991, the UN adopted the Principles on Mental Illness, which legitimized the use of forced interventions, which is usually with these torture drugs against people who psychiatrists diagnose. So consider the implications of that. In 2008, we have the first special rapporteur post-CRPD, Manfred Novak, finding that people with disabilities are often targets of violence and abuse, especially in institutions where they are confined. Among the kinds of violence and abuse are intrusive and irreversible medical treatments without their consent, including interventions aiming to correct or alleviate a disability, such as electroshock treatment and mind-altering drugs, including neuroleptics. So he is clearly characterizing the forced psychiatric interventions as being those that are attempting to correct or alleviate a disability and that they're intrusive and irreversible. The special rapporteur is concerned in many cases such practices, when perpetrated against persons with disabilities, remain invisible or are being justified and are not recognized as torture or other cruel, inhuman, or degrading treatment or punishment. He articulates the standard here. I still have that on that page. Whereas a fully justified medical treatment may lead to severe pain or suffering, medical treatments of an intrusive and irreversible character, when they lack a therapeutic purpose or aim at correcting or alleviating a disability, may constitute torture and ill treatment if enforced or administered without the free and informed consent of the person concerned. So that shows a diversity approach to disability and putting psychosocial disability squarely in that diversity. We have a right to our identity and our personality to not have that interfered with against our will, as well as our bodies. So being a form of physical torture as well as psychological torture at the same time, these forced interventions with neuroleptic drugs or any kind of similar drugs. So Novak then analyzes disability-based discrimination in relation to the anti-torture framework. The definition of torture in the Convention Against Torture expressly prescribes acts of physical and mental suffering committed against persons for reasons of discrimination of any kind. In the case of persons with disabilities, the Special Rapporteur recalls Article 2 of CRPD, which provides that discrimination on the basis of disability means any distinction, exclusion, or restriction on the basis of disability, which has the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise on an equal basis of all fundamental human rights and fundamental freedoms. So he's giving the definition in the convention, signaling that he's looking to the convention because of its approach to non-discrimination, which is transversal. He continues, furthermore, the requirement of intent in Article 1 of the Convention Against Torture can be effectively implied when a person has been discriminated against on the basis of disability. This is particularly relevant in the context of medical treatment of persons with disabilities, where serious violations and discriminations may be masked as good intentions on the part of health professionals. So what he's saying there is that when these acts of severe discrimination, such as I am assuming the acts he has just said are not being characterized as torture or ill treatment, but should be, such as electroshock and mind-altering drugs, that both the requirement of intent and purpose in Article 1 of the Convention Against Torture are satisfied, even if medical professionals claim they have good intentions in doing this thing. So I think that goes to what Guri was addressing before, and we're going to hear a lot more about the harms in the next panel. Disability-based detention itself can also amount to torture or other ill treatment, and he gives some factors to take into account, including the treatment inflicted, which I would argue has to include these practices like forcing neuroleptic drugs or electroshock on a person. Where is that? Okay, I had another piece on, the Special Rapporteur on Torture, Manfred Novak, also talks some about powerlessness as a situation related to torture. And so he's also really linking legal capacity and deprivation of liberty based on disability, deprivation of legal capacity and disability based on disability as being conducive to situations of torture and other ill treatment, or torture per se. The next significant output that I want to mention from the Torture Rapporteur was in 2021, a report on psychological torture by Niels Meltzer. And he explicitly addressed psychiatric interventions along with other practices that are that claim to be benevolent and are extremely discriminatory and coercive. He said, "It must be stressed that purportedly benevolent purposes cannot per se vindicate coercive or discriminatory measures. Practices such as psychiatric intervention based on medical necessity or the best interests of the patient generally involve highly discriminatory and coercive attempts at controlling or correcting the victim's personality, behavior, or choices, and almost always inflict severe pain or suffering in the view of the special rapporteur. If all other defining elements are given, such practices may well amount to torture. And that's the strongest recognition we have to date, post-CRPD, that we're actually going to start applying, the torture framework set out in 1986 that says neuroleptic drugs are a form or a method of torture. Meltzer also talks about torturous environments in which multiple forms of physical and psychological torture combine to create an environment that is torturous. I believe institutionalization, including all of forced psychiatry, certainly qualifies, and I think that links up very much with the guidelines on deinstitutionalization, which I'm going to talk about next. So, all forms of institutionalization are a multiple human rights violation for which redress and reparations are required, as well as a number of complex obligations to implement. It's an action-oriented document. There's a survivor-centered and reparative approach throughout the guidelines, ending institutionalization systemically and by releasing individuals from arbitrary detention, revoking the detention, allowing them to leave at will, providing emergency assistance for them to leave, also having the potential for preparation while still in the institution, and putting supports in place prior to leaving if the person chooses that, and can also be involvement of family or peer support if the person chooses. Institutional records on a person should be given to that person upon leaving and or expunged in accordance with the person's will and preferences. Institutionalization is said to refer to any detention or placement based on disability alone or on grounds such as care or treatment, irrespective of size, purpose, or duration. I'm combining from different paragraphs of the guidelines there with certain defining elements such as segregation from the community, lack of control over daily life, lack of choice in living arrangements, paternalistic approach, and service provision. And those are only a few of what is characterized as defining elements. But then the committee enumerates some places of institutionalization and then says, mental health settings where a person can be deprived of their liberty for purposes such as observation, care, or treatment, and or preventive detention are a form of institutionalization. So that would really include any psychiatric ward anywhere where any person can be deprived of their liberty by law or in practice. Mentioned specifically as well are psychiatric institutions, forensic psychiatric settings, halfway homes, protected or sheltered living homes, dementia wards, along with many others. And I mentioned dementia wards because in some situations, in some countries particularly, dementia is considered a psychosocial disability, and there's many people with dementia in psychiatric institutions as well. And many of us are getting older and have that to worry about in addition to forced psychiatry as we get older. Where am I? Okay. In the guidelines, we have the greatest recognition to date of psychosocial disability as diversity, removing us from medicalization as well as forced intervention. Persons with disabilities experiencing individual crises should never be subject to institutionalization. Individual crisis should not be treated as a medical problem requiring treatment or as a social problem requiring state intervention, forced medication, or forced treatment. And that's followed, so that was the part on individual crisis, and that is followed in many paragraphs later by this: states parties should ensure that options outside the healthcare system that fully respect the individual's self-knowledge, will, and preferences are made available as primary services without the need for mental health diagnosis or treatment in the individual's own community. and such options should meet requirements for support related to distress or unusual perceptions, including crisis support, decision-making support on a long-term, intermittent, or emergent basis, support to heal from trauma, and other support needed to live in the community and to enjoy solidarity and companionship. There's significant attention given in the guidelines to economic, social, and cultural rights, including direct economic support, immediately upon living institutions, in the short and medium terms for resettlement, and long-term assistance as needed. Safe, accessible, and affordable mainstream housing should be made available through public housing or vouchers, and it cannot be under the control of the mental health system or other institutional service providers, and cannot be conditioned on acceptance or treatment of services. So the guidelines are really systematically going through everything that has been done wrong up to this point and saying, you can't do this, you can't do this, you can't do this, you have to do this instead, you have to do this instead. And that's what I consider reparative. It recapitulates all the obligations of law reform, including full legal capacity, repealing authorizations for disability-based detention, including in mental health legislation, eliminate security measures and declarations of incapacity to participate in proceedings or be held criminally responsible. Also, assessment of services, development of new services, eliminating those that are institutional or otherwise incompatible with the convention. Now we're going to go to reparations, which is included in the guidelines on deinstitutionalization, and it's also a standing obligation under international law. There's an obligation of states under international law to provide redress and reparations to victims of gross human rights violations, as well as serious violations of humanitarian law, which is not what we're addressing right now. Torture and other ill treatment unequivocally is characterized as a gross human rights violation and obviously requires reparations. Reparations have also been addressed in relation to, called for in relation to arbitrary detention, discrimination against women, and by the CRPD Committee for Disability-Based Detention and other violations of the CRPD, prior to these guidelines on deinstitutionalization. And as we've seen, the guidelines has an entire section on calling for reparations and redress for institutionalization as a multiple human rights violation. I think it could very well be argued it's a torturous environment, and I believe the outgoing disability rapporteur, why is his name escaping me right now? Gerard Quinn had characterized institutionalization as torture in one of his later speeches. The core document on reparations is the basic principles and guidelines on the right to remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law. That was from 2005. Forms of reparation under that document are satisfaction, guarantees of non-repetition, restitution, rehabilitation, and compensation. I'm going to explain a couple that might not seem easy to understand. Satisfaction includes measures of recognition like apology, and it also includes cessation of violation, ending the violations. Sometimes that's also characterized as a prerequisite before reparations. Guarantees of non-repetition include, most importantly for our purposes, law and policy reform. Restitution is said to include restoration of liberty and other rights. It would seem that arbitrary detention and things like deprivation of legal capacity caused by explicit state law and policy also need to be addressed as cessation of violations and guarantees of non-repetition. You're violating the CRPD every second you are keeping every single person in a psychiatric institution against their will. So going to the guidelines on deinstitutionalization, Section 9, remedies, reparations, and redress. It calls for both mechanisms to investigate and raise awareness about the full scope of harms and individualized pathways to justice for individuals to seek redress and reparations, as well as restorative justice or other forms of accountability. Reparations should respond to, did I put that here? Should respond to the full scope of the violations and should be responsive to the violations suffered and the impact on an individual's life during and after institutionalization, including ongoing, consequential, and intersectional harm. All survivors know the impact of forced psychiatry doesn't stop when we are allowed to leave or when we escape, and I honor the escapees, of whom I know some. While all institutionalization is a multiple violation, aggravating factors may include, may include the denial of effective redress, length of stay, infliction of forced medical interventions or other violations or abuse, and inhuman or degrading conditions. And all of that applies to forced psychiatry, the denial of effective redress, infliction of forced medical interventions, and other things, and for many, the length of stay. And I think the repeated infliction for many people, even if they're not kept in an institution forever, for many it's also repeated time and time again. Reparations should include, beyond the obligations of deinstitutionalization stated throughout the guidelines, many of which, as I've argued, are reparative and constitute forms of reparation, as well as a simple obligation under Articles 19 and 14 of the Convention. So it should include formal apologies negotiated with all groups representing survivors of institutionalization, other educational, cultural, and historical measures to raise their status, automatic compensation at levels that redress pain and suffering and consequential damages, as well as health and healing modalities to repair harms caused by institutionalization. I'll note that assistance in withdrawing from psychiatric medications is included elsewhere in these guidelines, but it would also seem natural to think of it here when we're talking about health and healing modalities to repair harm. But it's not limited to that. Legal and social services to assist in getting established in the community and securing all rights and entitlements. Criminalization of disability-based detention and other acts of disability-related torture and ill treatment and other ill treatment. And other measures tailored to the needs of individuals and to the losses or deprivation they have experienced, and should respond to their immediate and longer-term desires and aspirations, such as reestablishing relationships with their children or family of origin, or retrieving any possessions that can be found. So these are meant, I think, to be illustrative. It can be very wide scope of what reparations look like. Truth commissions, in addition to their investigative functions, should raise awareness of the social harms caused by institutionalization, and that is an opening to a society-wide approach, encouraging everyone, I believe, to consider their relationship to these human rights violations, whether it happened to you or a friend of yours or a family member or someone in your environment, whether you have been complicit in any of these human rights violations. How can you relate to a reparative process? Reparations have to be survivor-centered and accountable, the mechanisms and processes and creation of them. Survivor involvement, there has to be survivor involvement in creating the mechanisms. Perpetrators cannot have an expert role or a role in creating them, but are invited to accept accountability. And this is the case throughout the guidelines as well. Survivors and their organizations, as well as other people with disabilities and DPOs, disabled people organizations, are the primary actors expected to play an influential role in deinstitutionalization plans and strategies, whereas those actors that have perpetrated institutionalization, including the mental health system, and in some cases, other kinds of service providers and anyone with an interest in maintaining institutionalization, are not to have an influence over decision-making related to deinstitutionalization. So with that, I close, and thank you. I look forward to hearing the rest.